Good afternoon, everyone. Thank you, GLD, for inviting us to this beautiful venue. Today we're here to talk about settlement negotiation considerations and global class actions. So why is this important? Why is this relevant right now? Well, as we all know, and the reason why we're here is legal frameworks across multiple jurisdictions continue to evolve as it relates to class actions. And I think everyone would agree that the trend generally is towards liberalization of these legal frameworks across non-US countries. And with liberalization of legal frameworks come more settlements, come larger settlements, come more complex settlements. So understanding the principles around settlement negotiation is not just beneficial, but perhaps essential in this evolving landscape. Settlement negotiations offer a strategic avenue to resolve disputes efficiently while avoiding the significant uncertainty and costliness of a protracted litigation. And they offer a platform for stakeholders to achieve mutually beneficial solutions. Lastly, in global class actions, implications are vast and interests are diverse. And so tailored solutions that arise through negotiated settlement might work better than, say, a court-mandated verdict. So on this panel, we're going to delve into negotiation strategies that prove effective in producing successful settlements. We're going to discuss how cultural differences may shape global negotiations. We're going to discuss important considerations that lay the groundwork for an effective settlement program. And to do so, we've brought a diverse perspective covering claimant side, defense side, upstream iDiscovery and data analytics, and then downstream settlement design and administration. So without further ado, I will allow everyone to introduce yourself, starting with Lucas.
Hi everyone, it's a pleasure to be here, so thank you much for the invitation, and I'm glad to be in this panel discussing this very important topic related to settling and finally putting an end into the class actions. So I'm Lucas, and I'm a partner in São Paulo office for Pinheiro Neto Advogados. We have about 120 partners, 600 lawyers, and I work but solely on behalf of the defendant. So it's a different point of view, and I think it's important because in order to reach a beneficial and a good settlement, it's important to have all stakeholders in place and in line. So I'm very happy to be here, and I have been doing this for 20 years, involving a lot of tech company, pharma, auto, consumer, and minorities class actions. So we'll be happy to discuss.
Hello, everyone. My name is Dan Regard. I'm very happy to be here as well. I am a technologist, fundamentally. I'm also an attorney. But for the last 30 years, I have worked on litigation and, yes, class actions, mostly in the United States, from the perspective of data. The last panel spoke about having data teams. I have the privilege of being one of those people, and maybe today I speak a little bit for the teams who could not be here. We work with data in litigation, both plaintiff and defense. We also analyze it and testify as to the reliability of data and the interpretation of data.
Hi, everyone. Good afternoon. My name is Pedro Martins. I am a partner at Mishcon Reya. We are a London-based firm, full-service firm, but at least half of our work is on disputes. My practice focuses on group actions, mostly those that have an international element. And by that, I mean group actions in which claimants sit outside of the UK or outside of continental Europe, but we represent them in courts, either English courts or continental European courts. I am originally from Brazil, and for the past 10 years I've been trying to bring cases that originate in South America into English and European courts. That's one part about what I do. The second part of what I do as co-founder of Somos, which is Mishcon's claims management company. I help to run all the operational sides of these cases and these settlements. We, of course, know that lawyering is a very important piece of this, but one should not neglect the importance of having a good claims management company next to you if you are a firm that finds yourself in one of those large pieces of litigation.
Thanks, Pedro. And my name is John Hays. I'm a managing director at Ankura Consulting, based in Washington, D.C. I work with clients across various legal jurisdictions and designing and operationalizing settlement remediation programs through the use of leveraging technology mostly. All right, let's jump right into it. Threshold question. What benefits do the various stakeholders in a class action hope to achieve through settlement as opposed to, a contested verdict?
I can start here, and from the defendant side, I think for sure when something goes wrong, I think the defendant wants to do the right thing, wants to settle, wants to make it right, but the main purpose for the defendant when entering into a settlement negotiation is to get a full release. So that's the main goal, and that's very important on how do you get release and how do you know that you are ending this case or ending at least what is known about the case, what's being terminated, what's still open. So this is very important, and this is the main goal and criteria for the defendant. And that's very important also because when you are discussing and entering into negotiations, it's important because even the plaintiff side must know what are the main interests of the defendant, and it's important to have the plaintiff's views and efforts in order to achieve those goals. So release is one thing, and of course, when you decide to settle instead of pursuing litigation, you avoid uncertainty. So you avoid the risk of a litigation, you avoid the risk of a bad decision that you do not control. You can control your reputation, so you can make it look the right way, look like you're doing the right thing. So reputation is also a key factor on the defendant point of view. And damage control, so something went wrong. So if you are settling because something went wrong, you need to make it right. So when you settle, instead of going for litigation, you are controlling the damage. So that's very important, and I'll cover a lot of topics related to that, because the main reason why I think defendants sometimes don't settle is because they cannot control the damage, and they cannot control what still opens after the settlement. So I think those are key factors.
Thank you, Lucas. From the data team, I work with both plaintiffs and defendants, and what we have seen is that in the last 30 years, and in the United States, definitely over the last 90 years, the amount of cases that go to final trial has diminished dramatically. Before the Federal Rules of Civil Procedure were implemented in 1938, 20% of federal cases went to trial. Today, it's less than 1%, which means we are settling out or abandoning our cases before we get to termination. We also know that that termination has changed from an average of 12 weeks to now 28 months. And that's just average. Class actions can last much longer, large cases can last longer, and large class actions can last much longer, as I'm sure this panel has experience with. We're closing a class action right now that is only 15 years old. Since these cases move toward termination, the idea that accepting or aiming for settlement sooner can save a lot of the duration and the uncertainty. And we'll talk later in this panel about how to reduce that uncertainty.
I guess from the claimant's perspective, and having in mind that most of the cases that come out of South America, they usually involve individuals on one side or public bodies, and of course a company on the other side. The most important thing is time. These people don't have time, so they want the case to be resolved as soon as possible. Secondly, is knowing how much they're going to get. One very interesting feature about these cases that originate on one place but are litigated elsewhere is that although the courts that will analyze the case are in Europe, the applicable law is usually the law where the damage happened. So this creates a very interesting framework for the case to develop itself. And when it comes to how much people will get for compensation, you're going to have a foreign judge apply, say, Brazilian law or Peruvian law or Colombian law and use those parameters to establish compensation. And you can quickly imagine how that becomes very complex. So settlement is definitely a way for people to have more certainty in respect of how much they're going to get. The third thing that I think settlement provides in the context of my practice is that it is a way to satisfy different interests within the claimant's cohort. So I just mentioned that we usually represent individuals and public bodies. By public bodies, I mean, for example, municipal governments. And of course, the interests of municipal governments are completely different than the interests of people, right? People just want a check, in basic. They just want to go back to their lives and try to make up for what happened. Municipal governments have much more complex interests that can be sorted in different ways. And I think a settlement allows for those characteristics to be dealt in a very tailored way.
Thanks, Pedro. So how does an effective discovery program facilitate downstream settlement negotiations? And Dan, why don't you take that first?
Very early in a case, we'll be tasked with understanding what data exists to identify potential class members, and what data exists to assess merits, and what data exists to assess damages. As the world has become more and more digital, we find that this type of information is more and more abundant. Whereas we would have substantial questions of those three issues 20 years ago, today we have much fewer questions, which means we have the ability to measure those things much sooner with certainty. So a successful discovery program is not just about the exchange of information with the opponent, but it's also about informing our own clients as to where they stand in a potential litigation.
Yeah.
And if I could
Sorry, go ahead.
add here, I think that's a very important point, and that's something that has been changing over the course of the last years, because from the defendant point of view, usually at the beginning of the case, the defendant holds more information than the plaintiff. Mm-hmm. So a couple years ago, the defendant would try to hold the information and avoid this being circled on. But I think as we are being more stabilized into these discussions, I think if you get early stages of discovery and document production and so on, you can try to have better information and can try to have a better settlement early on. Because if you don't, you cannot settle early on, and if you settle, that settlement will be challenged later on because additional information will be made available at a given point, and that settlement will be discussed. So when we are talking about what we are trying to achieve with a settlement, that is getting release, avoiding uncertainty, if I enter into an early settlement without proper data, that settlement is going to be challenged, and that's not the defendant's benefit. So we have been seeing that defendants are more willing to provide information and disclose them early stages if they want to settle the case right on.
I think every case is different. In some cases, again, you still have a degree of uncertainty, and I think those issues are very important that you bring up. Where there is uncertainty, you can't get closure. And that may require more time or bigger conditions of the settlement. But we're finding cases where we can tell really quickly exactly who's involved, exactly the duration, and the impact, and we can present that from the defense side to a plaintiff and say, there is actually no merit here, which we've done in employment cases, or in product liability cases, we can measure the damage immediately. Let's go for speed of closure rather than a protracted litigation. In other cases, what you bring up, I would agree with 100%.
Great. So across the stage, we represent experience in various legal jurisdictions, and those legal jurisdictions have different frameworks which govern settlements. So would any of y'all like to speak on, how those legal frameworks vary and how those variances end up shaping an ultimate settlement negotiation or settlement?
You want to start, Pedro?
Yeah, absolutely. I think, again, based on the background that I have on bringing cases that originate in South America, it is inevitable that whenever these cases are brought to Europe, there is existing litigation in the country of origin, and this creates a lot of complexity on the different stakeholders that need to be brought to the table in order for the case to be settled. And whenever you take the case out of the original jurisdiction and it becomes a global case, it needs to be settled globally as well. I think it is a common mistake from law firms to imagine that they will be able to treat these conflicts as being merely the ones that they have filed abroad, when in fact the way that things operate in the original jurisdictions is that you need to create a network of goodwill since the start with all the stakeholders that will have a say in how the case will be resolved. And this definitely involves going to the judiciary and to the executive powers to be able to resolve these cases in a successful way. Another thing I would say is, again, for everyone to consider the importance of claims management companies, going back to what Lucas said right at the start of the panel. It is important to create a single source of truth in respect of these cases. Sometimes we see on the media law firms saying they have hundreds of thousands of claimants in respect of a given case, but what does that exactly mean? Claimant firms need to create a way out of the case for the defendants, right? Everyone needs to see a way out of the problem, and that does necessarily entail having good data, not only in respect of damages, but in respect of the claimants, in the claimants themselves.
Yeah, I think it's always interesting to have these meetings with different jurisdictions, and the question is how those jurisdictions vary internationally, and that's very interesting because even though there are similarities, there are a lot of differences, and from the Brazilian perspective, and I think that's really remarkable because we saw in the previous panel about 10 class actions per year, and Brazil has an average of 60,000 new class actions per year. So those are every year, and we have like 350,000 pending class actions. So why is that? How come we have that huge number? We are a very litigious country, so we have like 80 million pending claims, but how come we have that big number of class actions? And the reason why, at least from my perspective, is that we don't have a successful option for settling. So parties must litigate all the way in Brazil because they do not have the legal certainty to settle. And why they don't have the legal certainty? And I think there are two factors here. The first one is legitimacy. Who is the representative? So you have associations, you have public prosecutors, you have even plaintiffs, individual consumers, you have multiple states. We have 27 states in Brazil. Each one has jurisdiction to rule the case. So you have pending class actions between states. So you do not have judicial certainty to enter into a class action without knowing that in a different state, by a different association or a different prosecutor, there will be brought another one. So this is going against the objective of class action. The whole point of a class action is to provide a reasonable matter to solve a problem, to solve something that happened. And of course, we are always talking about here about compensation and monetary adjustment and so on and so forth. But there are also other discussions related to class actions. There are a lot of class actions, and I think in Brazil, Europe, and US, discussing not only the damage redress, but the policy, how the agreement, how the companies, the tech companies, are able to collect data and how they can use such data within their artificial intelligence programs and apps and so on and so forth. And those class actions are very, very damaging because a judge can establish somehow that one company cannot use data or not. So when you left this to be decided by a judge, that's very, very dangerous. So this is a very different point of view than we have here from European countries and US, Canada, Australia, all other countries. So the first one is legitimacy. The second one is jurisdiction. And this is a problem that we have been discussing because Pedro was mentioning that England courts, Dutch courts, I think other courts consider themselves with jurisdiction to rule problems that happen in Brazil if, and please correct me if I'm wrong, Pedro, but if the Brazilian company has shares that they sold on stock exchange in London or in Dutch and so on, Amsterdam and so on. So if you settle in Brazil, but you still are under the risk of facing litigation for facing class actions in Amsterdam or in London, you really do not have the incentive to settle the dispute. And this goes against the best interest of the consumer, of the environment, or whatever is the underlying interest. So I think that the legal framework, and these are problems that all jurisdictions should probably have, they vary a lot. They have common grounds like opt-in, opt-out systems, and I personally think that opt-out systems are more prone to settlement than an opt-in system because from the defendant point of view, you have a better decision closure about who is inside or not, and that's fine when you know what's the risk, what's being left outside of the settlement. That's not a problem. But the problem is that if you do not know what's not being settled, you do not know what's the risk outside of that settlement. So that's are the reasons why a defendant will not settle the case and will say, I'll litigate, I'll fight this through. So I think those different characteristics from each international jurisdiction and legislation play a big role on how you are negotiating a settlement, what are the different aspects that stakeholders are taking into account, and how you could settle a dispute considering international aspects that, as mentioned in the previous panel, the world is smaller, we are globalized, so damages and problems that happen in UK or Portugal will happen all over the world. So those are important things to take into account.
John, I'll give you in the audience 2 reasons why one should consider settlement. And from a data person who believes in the power of data, I will tell you there are 2 circumstances where data fails. The first is, even if you have all the data you need to identify the class members and the merits And the damages, the different jurisdictions may be so complicated that waiting for the court to decide exactly which rules apply to which claimant can have a very protracted effect, but not a financial effect. So it's better just to round up and close it out. The other reason is, even though we collect a lot of great data, not all data can be brought to court. Some data we have trouble admitting or substantiating. But in a settlement, you can use this information with your opponent collaboratively to say, we may be able to prove this, but we can look at it now for influence. So where you can't prove your data, or it's just too complicated because of the legal regime, settlement is also very advantageous.
Yeah, makes sense. So, I don't think we can have an exhaustive answer to this in the next 20 minutes, but what strategies come to mind as most relevant and important when negotiating an effective settlement?
You want to start?
Sure. Please then.
We had a panel of economists just on the stage, and they were fantastic. When we look at settlement, we like to work with the economists, with the attorneys, to lay out different sensitivity analyses, to give them not a single number, but a range of numbers, usually in 3 or 4 dimensions, that allow them to provide some sort of trade-off on the size of the class, the length of the potential class action, the products that are included, if it's a product's liability, and the amount of money. So there can be some active negotiation, but also the opportunity for closure.
Yeah, I think there are many strategies from the plaintiffs and the defendant side when they are starting the case, and they probably know that this will end up in a settlement. But sometimes it takes a little dispute, so you cannot settle right away, and it takes little disputes. So you have tryout cases, and you see how that goes before the judge or the jury. So you have those initial cases that are very important, and parties usually spend a lot of resources on those initial cases so that they can see and have a better look on how the case would go. So if we had like 10 plaintiffs and that was the outcome, if Dan says you have a probably 2 million plaintiffs, so you can have a better discussion when please.
No, we have cases in the United States, and I'm sure elsewhere, where a part of the case can be handled collectively, like the discovery, but the individual defendants or individual plaintiffs cannot. And so we have a system called bellwether cases, where some of the cases will be tried to inform the parties on what settlement ranges might be, trying to narrow that range from the lowest unknown to the highest unknown to somewhere that's acceptable.
Yeah, and I think that one very important part is that there should be good faith in bargaining, in negotiating. You must establish a trust with the counterpart. Of course, when you are in a litigation, you're disputing, everyone is fighting, but when you are negotiating, you must establish trust. Without trust, you cannot settle any case. So that's, I think, very important from both the plaintiff and the defendant's point of view, that you can establish trust and you can be also, and that's very important, on a confidential environment. Because if the information that you disclose during those negotiation or a mediation phase, if that gets thrown into the papers and so on, then the negotiation is gone, there's no settlement, and that's bad for everyone. So I would say have a good faith among peers and keep it confidential.
My father said that once. He said to me, Dan, the secret to life is sincerity. And if you can fake that, you can do anything. Pedro?
Yeah.
You want to follow that,
I agree.
Pedro?
Yeah, I was gonna mention that from a claimant's perspective, it's interesting what Lucas said about the parties having to litigate a little bit at the outset of these cases, and what that means for claimants. Usually, when you're talking about cross-border litigation, is that the most important piece is establishing jurisdiction in the foreign court. And why is that the most important piece? Because that's usually where the cases die. It's usually where defendants are able to throw the case out into or back to the original jurisdiction. Once jurisdiction is established, the fact that the foreign judge will apply local law usually operates on the side of the claimants. And the reason for that is, although countries in South America usually suffer from a less efficient judiciary in terms of the effective resolution of these cases. It's no secret here that things take a long time to be resolved, at least in Brazil. I think Lucas and I can agree to that. From a material law perspective, there are very interesting concepts that operate in favor of claimants in terms of the extension of liability when you're talking about environmental matters or consumer matters. When you're talking about the burden of proof, inversion of burden of proof for environmental cases or consumer cases. And this will all come up at the time post-jurisdiction. And I think, well, at least that's the premise on the claimant's world, that this creates some apprehension on the defendants. So from a settlement perspective, the jurisdiction phase, it's always very important to claimants. Secondly, again, from the claimant's perspective, it is very important to create trust. That's why in all the cases that we litigate, we usually provide to the defendants the most accurate information possible in order to build trust in us as the law firm that will be able to actually solve the problem with the certainty that Lucas' clients need.
Oh, great. So with your experience across various legal jurisdictions, I'd be interested in how cultural differences may impact settlement negotiations.
I'm going to defer to my two colleagues who negotiate I don't usually negotiate the final numbers.
Yeah, I think that's one of the main important points here, because we all work for European companies, Japanese companies, Chinese companies, American companies, and each one of them have a very different culture and a very different way of how to do things. So one time, a deal settlement almost went away because the plaintiff did not agree to have a meeting at the Japanese time schedule. So that's incredible, but that was partially because of distrust among them. So they thought that one should do the time hour of the other, and that's crazy. How can you make that right? But cultural differences plays a big role here. One time I had a settlement that was already settled in America for $4.2 billion. And I was discussing the settlement with the counterpart and with the judge. And I always think that judicial oversight is important and helps to settle instead of damaging because of the legal certainty that I'm talking a lot about. And we were discussing, and my client had a proposition, and the judge asked me, why does an American life is worth more than the Brazilian life? So if you settle for 4.2 billion in America, why are you presenting this number here? And the point is, it's not that the company thinks that one lives matter more than the other, but the system is very different. In USA, you have punitive damages. You don't have that in Brazil, so you need to explain that to the judge. To litigate in America is very, very expensive. In UK, I think it's even more. To litigate in Brazil, it's not expensive. So the factors that that pose to the defendant in order to settle or not, or what's the number to settle, are very different. So those are cultural differences that always play a big role when you're discussing the settlement. And of course, the plaintiffs always want the biggest number that they can get, and the defendants want to have a reasonable number, and you try to settle with something that is reasonable between. Another thing that it's cultural. Some clients, they say, my number is this, and I'm not negotiating because I presented this number and this is it. But a lot of countries have like that negotiation pattern. You present 100, and I present 50 in order to reach 75. And that's different. A lot of clients don't have that perspective, but a lot of countries do. And it's important to respect the way that the country does business and how they negotiate and how they reach prices, considering different jurisdictions. So always very important, and we do it in our firm, is always have someone from our regional team, from the Chinese team or the Japanese team, even though they are not litigation lawyers, working along us in order to diminish those cultural differences.
I have just a small point to add, which is, again, specifically in the case of Brazil, how litigious the country is and how that impacts on settlement negotiations. Everything in Brazil, everything that is discussed, it's always under the premise that 5 minutes later, someone's going to file an injunction and everything's going to go bust. You always have the shadow of going to the judiciary immediately after a negotiation meeting hanging on top of you. And I think this proves to be very challenging sometimes. And that also influences, again, on who will be part of the negotiation. It is very hard for you to negotiate a case in Brazil only between the company, which is the defendant, and, say, a class representative. Inevitably, you will need to involve public authorities, the public prosecution office, the public defender's office, in order to get the case resolved.
I'm going to retract. There is a cultural difference on the data side. Different cultures feel very differently about the availability of data, the accessibility of data, and the privacy of data. So I can go to a country like Germany or Japan and say, this data exists, we can use it for settlement, and they will say, we're not going to collect it. We don't want to go there unless the court forces us to, which necessarily turns into what we call motion practice, motions to compel, and a protracted involvement of the judiciary, where that might not be the same at all in the United States. So we do have cultural impact on the availability of data.
So any other considerations come to mind that should be thought of during the negotiation process to ensure a successful settlement program, a successful operating settlement that reaches the people that it should?
I'll give you one.
Yeah.
Again, from the data perspective, we love the data. Almost every single class action that I've settled, the data was mostly right, but also partially wrong. And so we tend to assume sometimes, because we have a lot of detail equals correctness. It does not. And so I encourage my clients and the courts to realize this is mostly the right answer, but someone's going to be here who doesn't belong here. Someone will be in the class who was left out, and we just need to take that into account.
Yeah, I would also point out here that it's not obvious, but it's important to consider emotional factors. So when you're talking to the class representative, and of course it's a sensitive topic. We are always discussing sensitive topics in class actions. It's not just a commercial discussion and one company trying to gain money over another one. We are discussing difficult, sensitive topics when we are dealing with class actions. And so I always think and feel that this should be taken into consideration when you are discussing the settlement, so that you can understand the opposite part position and how they will respond to your proposal, so that you can build the agreement and build trust and enter into the final stages of negotiation that in the end of the day can be a number. So what's the indemnification amount and so on. But in order to reach that, sometimes if you just say, oh, this is 100 million, that would feel wrong, and you should not do that. So take it step by step, go follow on, doesn't just present it and be insensitive, even though, of course, we are striving for a deal, but take it the right way.
Yeah, I guess in my world, one non-obvious consideration would be to be very clear about how we're going to manage the group in the context of a settlement since the outset. So whenever you're representing thousands of individuals, again, municipal governments, businesses, different sides of businesses, you need to have a plan since the outset for whenever the defendant comes to you and say, okay, what do you want? How are you going to explain to the defendant what 100,000 people want? You need to be able to establish effective communication tools and also a legitimate way of identifying interests and communicating those interests, because this will guarantee that whenever time comes, you will be ready to speak on behalf of the group that you represent. Yeah.
Yeah. And from a settlement administrator standpoint, something I find interesting is the role that the defendant or defense counsel will play in the administration of a settlement. A common arrangement in the U.S. would be defendants give plaintiffs a bag of money, wash your hands and say, take it, and we're done. But we found, in some cases, especially in high-profile cases, where the defendant would be very much interested in an effectively run settlement administration, that they are more involved. And so having the parties kind of work out that involvement up front, I think, makes for a smoother administration. As others has said, that the administrator is ultimately beholden to the agreement, which is ratified by the court, but there's a lot of gray area, a lot of coordination in between what's in the agreement and how a settlement is administered. And so kind of understanding obligations and what role each party is going to play is, I think, really important. So we have a couple more minutes, and I'll take the opportunity to open it up to the floor if anyone has a question.
If we don't have any questions, I have a question for the audience.
Okay, let's do it.
How many of you have settled class actions involving U.S. litigation? Few. How many of you settled class actions involving South American litigation? Just want to see who we have here.
Yep. Okay. Well, thank you everyone for your time. Thank you panelists for your interesting comments, and thank you GLG for organizing this.
Thanks.